Hello and welcome back to another episode of Courts This Week, your go-to source for the latest legal updates presented by Livelaw. I'm your host Ostika Das and I'm here to take you through the most significant updates from this week, that is between 11th August until 17th August. From the corridors of the Supreme Court to local judicial proceedings, I'll be providing you with clear and concise summaries that keep you informed and ahead of the curve. Remember, for a more in-depth understanding, do visit our website at www.livelaw.in. In today's episode, we cover the RG Kar Hospital rape murder in Kolkata, the latest development in the Adani-Hindenburg saga, the Patanjali contempt proceedings, farmers' protests, and much more. So let's dive into the headlines. This week, the Supreme Court delivered a crucial judgment on the powers of states to recover past tax dues on mineral rights. This decision follows the court's earlier ruling on July 25th, where it affirmed that states can levy taxes on mineral rights under the Mines and Minerals Development and Regulation Act 1957. In the recent verdict, the court clarified that states can indeed recover past tax dues, but only for transactions after 1st April 2005. This means that while states can now collect dues for the past period based on the July 25th judgment, the recovery is limited to transactions post-April 2005. Furthermore, the court has provided a relief mechanism allowing the tax arrears to be paid over a staggered period of 12 years, starting from 1st April 2026 with no interest or penalties levied for demands before 25th July 2024. Chief Justice D.Y. Chandrachud highlighted that the cutoff date was chosen to align with the 2004 judgment in State of West Bengal versus Kesuram Industries, which upheld state powers over mineral rights. Notably, the recent order has been signed by only 8 judges, as Justice Nagaratna had dissented in the original judgment. In January 2023, Hindenburg Research shook the corporate world with allegations of corporate governance and accounting fraud against the Adani Group. The Supreme Court, in response, had set up an expert committee and directed SEBI to investigate Adani's financial dealings. Fast forward to this week, and a fresh Hindenburg report has added fuel to the fire by alleging a conflict of interest involving SEBI's chairperson Madhavi Puribak and her husband, who allegedly had investments in offshore funds linked to Adani. In light of this, an application has been filed in the Supreme Court seeking the acceptance of an earlier plea that demanded SEBI complete its ongoing probe against Adani Group. The petitioner Vishal Tiwari had previously requested the court to enforce a 3-month deadline for SEBI's investigation as suggested in January. However, the registrar had dismissed this application, noting that the court had only indicated a preferable timeline, not a strict one. Now, Tiwari is challenging this refusal, citing the new Hindenburg report as a significant factor that underscores the need for a timely conclusion to SEBI's investigation. In a significant development, the Supreme Court has decided to close the contempt proceedings against Patanjali Ayurved Limited, its managing director Acharya Balkrishna and co-founder Baba Ramdev. The case stemmed from allegations that Patanjali had violated a court undertaking by continuing to publish misleading advertisements about curing certain diseases, despite a previous assurance given to the court in November 2023 to refrain from such practices. The contempt case was initially brought forward by the Indian Medical Association, which objected to Patanjali's advertisements that attacked allopathy and made unsubstantiated medical claims. This week, a bench comprising Justices Hima Kohli and Ehsanuddin Amanullah delivered its judgment, accepting the apology tendered by Patanjali and taking into account the steps that the company had taken to rectify the situation. However, the court issued a stern warning, making it clear that any future violations of court orders would result in the reopening of these proceedings, signaling that the court's tolerance has limits. This week, the Supreme Court reaffirmed a critical legal principle, declaring that bail is the rule, jail is the exception, even under special statutes like the Unlawful Activities Prevention Act 1967 or UAPA. This ruling came in a case involving Jalaluddin Khan, who had been accused of renting his property to members of the banned organization Popular Front of India for conducting training sessions. The prosecution has alleged that these sessions were part of a plan to regroup former PFI and Students Islamic Movement of India members to carry out violent retaliation. Despite these serious allegations, the Supreme Court granted bail to Khan, overturning a Patna High Court decision that had denied him bail. The court emphasized that while the charges might be grave, the denial of bail in deserving cases would violate the rights guaranteed under Article 21 of the Constitution. The bench, comprising Justice Abhay Oak and Justice Augustine George Massey, reiterated the importance of upholding the principle of granting bail when the case justifies it, irrespective of the severity of the allegations. In a recent ruling, the Supreme Court dismissed a petition that challenged the decision to conduct a re-examination for the UGC NET 2024. The original exam, held on June 18th, had over 9 lakh candidates participating. However, concerns about the exam's integrity arose after the National Cybercrime Threat Analytics Unit under the Ministry of Home Affairs flagged potential issues leading to its cancellation. The Ministry of Education decided to reschedule the exam for 21st August, prompting the petitioners to approach the court. They argued that a recent CBI investigation revealed that the evidence suggesting a paper leak was fabricated, questioning the rationale behind cancelling the exam. The petitioners contended that the decision caused unnecessary stress and wasted the resources of the students who had diligently prepared for the exam. However, the Supreme Court, led by Chief Justice D.Y. Chandrachud and comprising Justices J.B. Pardiwala and Manoj Mishra, dismissed this plea. The court emphasized the need for finality, noting that only 47 petitioners challenged the re-exam out of the 9 lakh students involved. This week, the Supreme Court addressed the ongoing issues surrounding the farmers' protests and the blockade at the Shambhu border between Punjab and Haryana. The bench, led by Justices Surya Kant and Ujjal Bhuiya, took up Haryana's plea against the Punjab and Haryana High Court's directive to unblock the Shambhu border. In response, the states presented a list of individuals who could be part of a negotiation panel to mediate between the protesters and the government. The court commended both states for their efforts and directed key officials from Punjab and Haryana to convene within a week to discuss opening the highway partially, particularly for essential services, students and senior citizens. In a significant development, the Supreme Court also rejected Haryana's request to stay the High Court's order mandating a judicial inquiry into the death of a protester, Shubkaran Singh. Singh died on February 21st while protesting for a law guaranteeing minimum support price for crops. His family alleged that he was killed by a bullet fired by Haryana police, prompting them to seek justice through the courts. The High Court had previously ordered the formation of a 3-member committee headed by a retired judge to investigate the incident, a decision now upheld by the Supreme Court. This matter has been adjourned to 22nd August for further hearing. This week, the Calcutta High Court took decisive action in response to the alleged brutal rape and murder of a second-year postgraduate student at R.G. Kaur Medical College and Hospital in Kolkata, a crime that has sparked widespread outrage across the country. The court, with a bench comprising Chief Justice T.S. Sivagnanam and Justice Hiranmay Bhattacharya, heard multiple pleas, including one from the victim's parents demanding a fair investigation. The High Court questioned the state government after it was revealed that the police had initially registered the victim's death as suicide and delayed informing her parents, who were made to wait for hours before being allowed to see her body. Dr. Sandeep Ghosh, the college's principal, had resigned over the incident but was promptly reappointed as principal of another institution, a move that the court criticized as lacking empathy. The court ordered Ghosh to take a long leave or face court orders. Expressing concern over the mishandling of the investigation and the lack of progress, the High Court also transferred the case to the Central Bureau of Investigation to prevent any potential destruction of evidence. The court emphasized that such a transfer was necessary to maintain public confidence in the investigation and deliver justice. Later in the week, the High Court also scrutinized the state government over its handling of the alleged rape murder, questioning the state's failure to prevent large-scale vandalism at the hospital on 14th August amidst widespread protests and vigils. The court criticized the police for not anticipating the mob of 5,000 to 7,000 people that overwhelmed the hospital, leading to injuries among law enforcement officers. The bench noted that such a gathering should have been detected by the police intelligence wing and questioned why curfew orders under Section 144 of the Criminal Procedure Code were not imposed to control the situation. The court declared the incident an absolute failure of state machinery and emphasized the need for better security to protect hospital staff and ensure their ability to work safely. In the meantime, the People's Union for Civil Liberties has also approached the court, seeking a court-monitored investigation and compliance with the Sexual Harassment of Women at Workplace Act, or POSH Act, of 2013. In a notable development this week, the Delhi High Court granted interim protection from arrest to former IAS officer Pooja Khedkar, accused of misrepresenting and falsifying facts in her application for the 2022 Union Public Service Commission Civil Services Examination. Justice Subramaniam Prasad issued notice on Khedkar's anticipatory bail plea, ordering her to cooperate with the investigation. This case has gained significant attention, especially after Khetkar's plea challenging the cancellation of her candidature was dismissed last week. The UPSC had informed her that the official order of cancellation would be communicated within 2 days. A petition challenging the exclusion of Section 377 of the now repealed Indian Penal Code from the new Bharatiya Nyaya Sanhita has been filed in the Delhi High Court this week. Section 377, which previously criminalized consensual carnal intercourse, was partially struck down by the Supreme Court in the landmark Navteej Singh Johar case, decriminalizing consensual same-sex relations while retaining provisions against forced intercourse and bestiality. However, the BNS has completely omitted these provisions, sparking concerns that forced carnal intercourse against men and bestiality are no longer considered criminal offences. The petitioner's counsel argued that the absence of Section 377 poses a significant threat to individuals, particularly within the LGBTQIA+ community. This matter was mentioned before a division bench of Acting Chief Justice Manmohan and Justice Tushar Rao Gadela, who agreed to list it for an urgent hearing. This week, the Allahabad High Court provided important clarifications on how the new criminal laws, including the Bharatiya Nagarik Suraksha Sanhita, will apply to ongoing cases. The court observed that if an FIR is lodged on or after 1st July 2024 for an offence committed before that date, it should be registered under the IPC. However, the investigation should proceed according to the BNSS. Furthermore, if an investigation was pending as of 1st July 2024, the investigation will follow the CRPC procedures, but the court will take cognizance of the police report as per the BNSS. All subsequent proceedings, including trials and appeals, will be conducted under the BNSS framework. This clarification came during the hearing of an FIR quashing plea filed by Deepu and 4 others accused in a rape case. The court had earlier questioned the local police for not applying BNSS provisions in an FIR lodged on 3rd July 2024, and the Superintendent of Police had provided an affidavit explaining the situation. The court accepted this explanation but clarified the applicable legal provisions going forward. And that's a wrap for this week's Legal News Roundup. But before we bid adieu, the entire livelaw team has a small request for our dedicated viewers. As an independent and fact-driven media organization, we are deeply committed to fearless and ethical journalism. To continue bringing you the latest legal updates, especially in this dynamic audio-visual format, we rely on your support. Here's how you can help. Give our video a thumbs up if you found it informative. Share it with your family, friends, classmates and colleagues. Make sure you subscribe to our YouTube channel for more insightful content. Drop your valuable thoughts and feedback in the comments below and hit that bell icon to stay updated with our latest releases. Don't forget to visit our website at www.livelaw.in for our in-depth reports and analysis. Not only this, but the Livelaw channel offers memberships for only ₹89 per month. Become a part of LL supporters today to access exclusive perks such as loyalty badges next to your name in comments and live chat, priority reply to comments, and for our student pass audience, early access to explainers and legal updates. I'm your host Ostika Das, and it's been a pleasure bringing you this week's Legal News Roundup. Until next time, stay informed, stay engaged and stay tuned to Livelaw. Thank you for watching.